So now we have quite a bit of time for questions, and I'm sure there must be a number of questions after those stimulating presentations. Sure, Doug and then Harry.
So Doug Harris from UBC, thank you all very much for those papers. I've got quick questions for all of you, if I may pose them. Doug, for you first. Well, I don't disagree with any of the ideas that you have about how we should be challenging ourselves to think about what it is we do in law schools. I guess I disagree with your framing of the great disconnect. If I or anybody were to walk into my law school at UBC, we would see all of the spaces, virtually all of the spaces, named by law firms. $36 million of the building has come from law firms. If I look at the list of teachers who are teaching at the law faculty, there's 45 full-time faculty and over 100 adjunct faculty. So there's all sorts of, I think, if you look at it objectively, there is no disconnect. Now, that doesn't mean we shouldn't be challenging ourselves to think about what it is we do, but I guess I would take issue with your framing of the great disconnect. Alice, for you, my question. I really like your idea of framing the role of the law school as having teaching or helping students learn to live their lives, their professional lives, through this idea of the rule of law, that they should think, operate, and live their professional lives within the law. And I think your subtext was we're actually doing that pretty well, or at least we need to be cautious in any change that we lose that part. And I'm wondering if you could just speak to some of the tangible parts of a legal education that you think are particularly important in teaching students how to live their professional lives within the law. And Hugh, for you, I was interested that the skill that you picked up that you thought lacking most clearly was the skill of writing clear, unambiguous prose, and perhaps in a journalistic frame rather than in an academic frame. But thinking of what law schools select when they're hiring faculty, the skill that they're perhaps selecting most prominently for is that of the writer. Now, it may be the academic writer rather than the journalistic writer, but there seems that of the skills we might be best positioned to teach, writing would be near the top of that list. And so I'm wondering if you might flesh out a little bit more what it is that you think is lacking in the students, the articling students or the young lawyers that are coming to the firm, and how it is that we might think about developing our capacity to teach that particular skill. Thank you.
I don't disagree that every law school has quite a number of adjuncts coming in to teach, and that their point of contact is with the students, but they have very limited contact with the rest of the faculty. They come in, they teach the course, and they go home or go back to work. And I think we need more cross-pollination between the faculty members and adjuncts, which I don't think is really there. But that's just one aspect of it. I think the profession doesn't have the benefit of having law professors involved in many of their other activities, like the CBA or like the law societies. I think there has to be these institutional links between them so that law schools, it's not just a case of forcing law schools to change. I think law schools could have influence on the other organizations as well. If law schools choose to play their role as they should, I think, in these organizations, I think they could have an impact the other way too. That's what I was trying to focus on.
I'm actually, I would say, I'll give an example, Doug, to answer your question. I mentioned in my talk that I didn't feel in some ways that I was very prepared for legal practice or fully prepared for legal practice by my legal education. But I've often said that actually the best course I took in law school for teaching me how to be a lawyer was Ernie Weinrib's first year torts class. And people don't necessarily think of Ernie Weinrib as, Mr. Practice. But what he taught in that class was how to take law seriously as a conceptual framework for thinking about human relationships. And to say, if you have a problem between two people and, or some interaction which doesn't go very well because it's a torts class, how is it that the law allows you to frame and to think about and to assess that situation and to work with it conceptually? And I would think I would draw from that overarching lesson. I think the first year curriculum at law schools, I think the way that we immerse students in thinking about the law and in working with it as something that they have to, I mean, not necessarily the case method in and of itself in the sense of reading a case, but the combination of using and thinking about cases and what you draw from them and what you can't and how you use those to think about human problems as they arise. But I also wanted to say that I think, and I meant to mention this in my talk and I forgot, so I'm going to hive onto your question to do so. There's nothing about what I'm saying here which dooms people to reject the lawyer's activist point that Hugh made. And that I think what law school can do, though, in having courses and opportunity for students to critically engage with the law, so theoretical courses or perspective courses, is they allow students to think about social change within a rule of law society. And someone yesterday made the observation of contrasting Martin Luther King as someone outside the law and Thurgood Marshall as someone inside the law. But I actually reject that suggestion because Martin Luther King was very deliberative in his violation of the law. He did not say simply, you know, I reject the law. He viewed this law as something that ought to be changed in order to create a more just and fair society. So I would view him actually as very much someone working within the law. And I think one of the things that we do well in law schools is to give students that critical perspective, but one that ideally takes the law seriously as something that you think about. So those are the two of the things that I think are good.
So my question had to do with elaborating on legal writing and how that can be instilled in a superior way, perhaps among law students. It wasn't the cardinal virtue, it's just one of a set of skill sets that I think
do something which is unrecognizable as law. And I am saying that as lawyers and as law professors, if we don't take law seriously to that extent, which is very different from saying there's right answers. Law is a contested space. It's an argumentative discipline. Neil McCormick's written about that. Jeremy Waldron has some terrific recent pieces on it on the rule of law. It is not a situation of finding and identifying rules, but it's an argumentative practice, and there are things that are recognizably outside that argumentative scope. The demand letters that are sent to those clients which are asserting a claim which is legally wrong are outside that scope. And all I am saying is that in engaging with doctrinal law, and I'm talking about critically engaging and theoretically engaging, we are saying to our students through that entirety of that learning process, law is something that there are things that are inside it and outside of it. And when you evaluate your students, and actually I meant to say this in response to Doug's question, one of the main ways in which we deliver this message is through our examinations. And I think as well, I would just say that I think when professors make an opposite claim, and I used to sort of say things like that to my students, but then I realized that no, they could get it wrong on their exams, and I might as well tell them that, because they can and they will, and those students will not do very well. I could give you examples if you want me to be here for another hour or so. But it's a question not of saying law is a series of rules that you have to identify and apply in a kind of mindless way, but is saying law is a serious thing that governs our society that you have to engage with as a lawyer and take seriously as a lawyer, and that if you do not do that, that is a fundamental failing in your craft. It's not the only way to fail. Under-advocacy for clients is actually probably more of a problem than over-advocacy, is not if you're white in case, but if you're a person dealing with an under-resourced lawyer, that's more of an issue. That's not the only way to get it wrong, but it's an important way to get it wrong. And that when we engage doctrinally with our students, not teaching them doctrine, but engage with law as a construct that they have to work within, we are delivering an implicit message about what it means to be a lawyer. And it's that implicit message, not how you teach it, but the implicit message that I think is a central part of our curriculum that any reform movement has to be careful to preserve. And that's a positive point, not a negative one.
So I think I'm going to use my discretion as moderator to make time for one more question. Nicole?
Okay, just quickly, so we'll go to Mike. I'm the vice president of the Canadian Association of Law Teachers, and I guess this is more of a self-promotional comment than it is a question. I'll make it short. We're having a conference next June, University of Manitoba, to celebrate their centenary with the Canadian Law Society Association, where we're hoping to continue this kind of conversation. This panel did a very good job of saying, how do we bridge this? How do we have a conversation? And our organization
Speaking of self-promotion, if I may be permitted 15 seconds. I'm the president of the Association for Canadian Clinical Legal Education, and we're having our conference in Halifax, Nova Scotia, October 16th to 19th. And those of you who are, whether you're clinicians or faculty members or students come for, there's no registration fee, by the way. And I hope those of you who are deans or faculty members will maybe make a little bit of money available for students and faculty to come out to our conference. So thanks very much for that 15 seconds of
Okay, I think
commercial time.
that's all the time we have for conference promotion. Maybe if you speak to Wayne, he'll let you jump up this afternoon. But I'd like now to just very much thank all of our panelists for very interesting presentations, and thank you for your questions.